going to be about is strictly conservation easements. You know that there are many different kinds of tools that we can use to protect our land. You know, there's purchase or development right. But we're going to talk specifically about conservation easements and what that might mean for the protection of our horse-friendly farms. A conservation easement is a legal tool. It is a legal contract between the landowner and a 501c3 organization, conservation organization, or a governmental entity. And that is the preservation of conservation values and the protection of public benefit. Those are the two most important things to remember when you're talking about conservation easements, because the conservation easement law is derived from the IRS code, the federal law. And then, of course, each state has their own conservation easement code based on the Uniform Conservation Easement Act of like 1980, whatever it was. So that means that in order to meet the code and to have a conservation easement that will pass law and withstand a potential audit, big key word because of what is happening with our industry and the IRS, and or a judicial claim, we must protect conservation value and public benefit. Public benefit, we'll talk about it in a minute, it doesn't mean public access, but it means public benefit. What is public benefit? What is the public benefit of Shenandoah Farm if I'm not a rider and I never come to a clinic? It is that I can drive by on that public road and look and see it. That's my public benefit. So that's an example. What's conservation value when you're talking about a horse farm? Conservation value might be that open space right there, just looking out the window and seeing the open space. I'm not looking at a house. The conservation value might be the fact that there is agriculture still going on. Another conservation value might be the woods over here, the preservation of those trees. So we see there's a lot of broad determinations and definitions for those things, but we must define those things in order to have the easement document viable in a court of law. Perpetual. Conservation easements under the federal code are perpetual. You hear about different governmental programs that are term. Wetland easements are term easements for 30 years. Conservation reserve program might be a 30-year term where you will promise to, grow hay or grow grass. These easements must be perpetual in nature. We always kid around about the fact that when we put a conservation easement on a property, we're protecting it from our grandkids. We're protecting it from the next generation that might not love the land like we do and might say, oh, I can get a couple $1 million, I'm selling out to a developer, and then there you go, landscape gone. There are many potential financial benefits that a conservation easement may provide for the landowner, and we're going to talk about those. We promise the continued use of the land. Don't be mistaken, a conservation easement interest is very different than the fee interest, the ownership interest that you have as landowner. When you are putting a conservation easement on your property, you're not giving up the right to own it or the right to use it. You're just setting aside the development rights, theoretically. The promise is economic return. If it's a farm, a working farm, you can still make your money off your working farm. If you have it open to commercial hunting, you can still commercially hunt. So it does not strip the economic returns of the land from the landowner. And then more importantly, this document, a conservation easement, is a partnership between the landowner and the conservation organization or governmental organization that's going to hold it.